in just a moment. Just a couple of announcements. For those of you who have registered for continuing legal education credit, the CLE forms are now available. You can pick them up at the registration desks. And if you have registered for CLE but haven't yet signed up, you can certainly still do that now, and the materials are available there. I know we've we always, in all of these conferences, have issues with time, but I'll encourage the speakers and the panelists and the moderators, whatever you didn't get to say, you'll have an opportunity to include it in the compendium of the conference, and so then there will be a record of your remarks, both what you said here and what you have prepared. So it won't be lost. It'll be made available for all of us. So we will now turn to the second panel, Emerging New Services, Their Impact on Collective Management of Copyright and Related Rights.
Yes, good morning. Thank you for joining us. I've been given special dispensation, along with my promise to keep my introductions short, to introduce some of our distinguished panelists. Steve Lubin, at my far left, is the CEO of Media Guide. Prior to his association with Media Guide, he was vice president of ASCAP's Enterprise Group. Prior to his current position, he served as the first chief of staff to ASCAP CEO John Lofomento. Daniel Gervais, next to me, is the acting dean, the University Research Chair of Intellectual Property, and the Osler Professor of Law at the University of Ottawa. He's recognized as an expert in the area of GOT, which is now the WTO, and is vice president of the International Affairs for the was at one time vice president of International Affairs for the Copyright Clearance Center. Eric Baptiste, the Director General of CISAC, the International Confederation of Societies of Authors and Composers, is with us. Under Eric's direction, the performing rights organizations and the rights organizations throughout the world strive to provide services to authors, composers, and artists. I would encourage you to read Mr. Baptiste's biography that has been handed out. If you are not duly impressed while you read that, the last couple lines, that he has been awarded the French Medal of Chevalier of the Order of the Arts and Letters. We're pleased to be in your presence. Jim Griffin is with us. Jim is the managing director of One House, and he is an author and is a frequent speaker at major colleges and universities throughout the United States and indeed throughout the world. In a prior life, Jim was with Geffen Records and distributed the first full-length commercial song online by Aerosmith. He is also the co-founder of the Pho Group, which, by the way, is named after a bowl of Vietnamese soup. I missed the soup when I was there, but I had some other interesting stories. Jim is well known inside the Beltway. He's testified before various copyright matters and hearings. He's testified before the Copyright Royalty Board on satellite radio rates and as such, and currently advises Nokia's Research Center in Helsinki, Finland. So please make our panelists welcome. Many years ago, I witnessed an educator in an attempt to calm down a group of students who were upset and deeply concerned over a divide that had occurred in the process of this group working on a project. And it didn't appear at that moment like the project was going to turn out successfully and this group of students were going to get a lesser grade than they had anticipated. Well, the professor's comment was, don't get discouraged. Everything looks like a mess in the middle. Don't worry, communicate, keep working, and everything will turn out all right. With that in mind, I would like to ask each of our panelists a question. We seem to be caught in a tug of war between those who believe that copyright law is antiquated and that the protection historically afforded to creators must be rolled back for the good of humanity in this worldwide environment which is increasingly being driven by technological conveniences. And I say conveniences because I don't mean technological needs. I mean conveniences. We have DEMA, the Electronic Frontier Foundation, Creative Commons, and others. On the other hand, as we well know, we have record companies that are hemorrhaging money. We have publishers, songwriters, producers, and other creators that are losing a fortune to illegal downloading, image stealing, and other forms of obfuscation. We have organizations like the RIAA, IFPI, and others putting their finger in the dike, trying to hold back this wholesale disregard for copyright. So my question, which I would appreciate each of our panelists answering, is what words, what advice, what message do you want to send to either side or both sides that you think might help build a bridge between the two sides? And I'll start immediately to my left.
The answer is yes. Well, first of all, just a quick word to say thank you to Michael and Patrick and WOPO and Larry for the invitation. Well, it's told to put this on my tie. Is this working? A complicated question. Let me, if I can, approach it from two different angles. You said in your introduction, in presenting your question, you said, well, let's look at historical context. I'd like to do that for a second. Usually, the copyright history, the traditional copyright history that we read for common law countries, at least, starts in about 1710, Statute of Anne. And if you think about it for a second, from about that date, 1710, to somewhere in the mid-1990s, I'm talking for about 290 of the 300 years of copyright history, where was the consumer? Where was the end user in this picture? And the fact is, nowhere. You go buy a book, you have a sales contract, but you don't sign the license. You go buy a record, a CD, same thing. And what has happened beginning with the Napster and then all the peer-to-peer systems and the authorized alternatives, the legal alternatives to those systems, is that these end users are now part of a system that wasn't built initially to have them part of this equation. And I think that is a source of tension. It doesn't mean we need to change the system, but we need to realize that historically this is new. So we need to adapt. We need to understand that the picture has changed. Up until the 1990s, you had copyright, which was kind of a substratum to allow people to have contracts. Professionals, publishers with authors, producers with authors, with distributors, with producers of concerts and promoters and so on. And all of a sudden, now you go on the internet, you access this content, and you have to click I accept. And very often, if you read what you've accepted, it's 28 pages. And you probably waived a number of rights that you had until the 1990s, with some of which are fair use and others that we know very well. But let's just realize the picture has changed. I don't want to talk for too long, but it's an important point. The second thing that I think has changed is that these end users have rights that copyright never had to fight in court before, at least not very often. How often have you watched on TV the final battle between copyright and privacy? Not very often. Between copyright and consumer protection. Richard Owens mentioned Apple this morning. Those are fairly new battles as well, and we have to understand that these battles are being fought for the first time in most cases. So again, that's a change. So all of this turbulence is something I think that can be explained. It doesn't mean the system of copyright needs to change fundamentally, but it means that it's facing new challenges that it hasn't faced before. If I may take another 30 seconds, I think another thing that has changed that would probably 3 hours to explore fully is up until the 1980s or so, copyright was regulated as intellectual property. Since the 1990s, it has been regulated as trade internationally. It is part of trade agreements. Trade agreements are not about theory of whether copyright is property or whether trade is about being pragmatic, making things work, and getting remedies when you can show that you've faced some adverse impacts on your trade. That's another fundamental change that I just wanted to mention, because when you read a lot about copyright these days, people really approach it as tradable commodity, not as something almost sacred that a lot of people who've been doing copyright for a long time as such. So these are all fundamental changes, and I just wanted to mention them because they're all relatively new, fairly new in the history of copyright. Long answer, but hard question. I'll stop there.
Well, the main advice I think would be that we should all work together to deal with those issues. And another issue I think to be mixed is the global nature of some of the services. In the past, we were able to deal with copyright issues within of laws, one set of court decisions. You have to make sure that whatever happens is compatible with multiple jurisdictions, multiple frameworks, and that is creating a very, very difficult challenge. If you add to that for example, this is earlier this morning, you have a kind of tension between copyright law that remains kind of based and control that is a European prerogative. You have another level of confusion. But the most important thing is that we have to make sure that those issues that involve the public, the audience, the consumers, involve them with copyright problems. That should not happen. The end users, public, should not be worrying about copyright issues. Very hard to gather. People that represent authors, composers, publishers, record companies, other rights holders, performers, of course, but also to go back to a situation where the consumer is worried about or is waiting or whatever. That involves that we talk to each other probably even more than today, that we each recognize the value of the portions of the rights we have. Record companies bring value, authors bring value, publishers bring value. All recognize that and not chip away at the other's rights. We should also be engaged in meaningful dialogue with people representing. They are politically influential, almost natural. We have to make sure also that we use technology as appropriately as possible, and we should not be afraid of technology. Lots of the problems that we are facing at the moment are created by fantastic technologies, and some of those I'm not being too naive. I know that the answer is not in the machine entirely, but we should embrace technology. That would be my basic advice. Let's work more together rather than fight each other. Probably easier said than done, but we see that we're very, very determined to do whatever we can to make this happen.
Jim, what bridge-building words do you have for us?
Well, I want to echo the thank yous, and I extend them because I want to thank Vanderbilt for the use of this hall and all of you people for filling it up, because I don't think it would matter if we were here if you weren't here listening and attending and interacting with us. But I do love the question because it's a place where I've staked out what I hope is my business territory, and that's advising those on both sides of the spectrum, and I do. And I think one of the essential things I try to tell people on both sides is I try to remind them of how forward-thinking Marshall McLuhan was. You know, this very influential Canadian who wrote in the 1960s the work Understanding Media, The Extensions of Man. There was so much in McLuhan's thinking and in his work that anticipated where we would come. And frankly, when I was a student in college, I didn't understand a word of it. I just knew you had to repeat that on a test if you wanted to get an A. And also that McLuhan was very good in that Woody Allen movie, Annie Hall. You know, it's just great. Woody saying, oh yeah, well, I've got Marshall McLuhan right here. He'll tell you what an idiot you are. Now, you know, that aside, a very interesting passage I found from McLuhan once, and it wasn't in his book, it was in an interview he did. And basically McLuhan said that we would never understand the media of our times He said that it was like the water in which a fish swims or the air that we breathe, that we're so involved in it that we can't understand it. And I'm sure McLuhan was right about that. And he said, if you want to understand your media, look in the rearview mirror of history. And I think that's right. And that's the advice that I give. And so my suggestion, without going too far back, is that I like that time period right at the 1920s because, boy, was that important. You know, acoustic becoming electric was far more savage than electric becoming digital. Now, we think we're very special. Of course, we're past the year 2000. My God, we live in a future many of us thought would never come, and we think how special we are with our 10,000 days of dot-com fever at most. But the 1920s were a time of far more dramatic change. You know, here you've got a time period where electricity starts spreading around the world, and within 10 years, not only do we gain loudspeaker systems, but we get radio, television, broadcast. Let me reemphasize. Before the 1920s, artists, for the most part, controlled their art with their feet. If they weren't in the room, you couldn't see them or hear them. And 10 years later, you can see someone in color across the ocean. They had done an experiment in 1928 with color television. So in such a short time span, we went from almost complete control to just an unimaginable loss of control. I mean, they can see me, they can hear me, and I can't see them. They're so far away. And so I think if we look at that time period where acoustic became electric and we look at the solutions that arose around that time period, they're totally applicable today. You know, and that's what makes this conference so great and so well-timed. Because it was actuarial economics. What I mean is a pool of money and a fair way of splitting it up that replaced actual control. And so it's been throughout our history. Actuarial economics continue to replace a loss of control. This pool of money, this fair way to split it up, that is what has gotten us through these times. And I mean almost without exception. So if we trace just very, very quickly, loudspeaker systems, public performance, pool of money, fair way to split it up, broadcast, radio, television, cable, satellite, pool of money, fair way to split it up. As recently as a few years ago in the United States, we adopt pool of money, fair way to split it up to get webcasters on their feet, streaming over the internet. And so I think it is a relatively short leap to realize that for that which does not stream, we will likely come to that same conclusion. And I think it's because, at its essence, as much as we love copyright, and I do, and if this is misinterpreted, I've arranged for Peter Jenner to throw something and create a disturbance so I can rush out the door. But I think copyright has become, over this time period, copy risk. And I say that because while I agree it's nice and it's right and it fits with my thinking that you should be able to control every copy of a song or a movie or a book, and furthermore, that control should evidence itself in your getting paid for it. Quite frankly, we're in a bonfire of that sort of thing, and it's not going to stop. I mean, I've got a copying machine in my pocket, another one on my desk at home, and another on my desk at the office. Now, in a world like this, where they're all hyper-connected, your right to control your copyright becomes increasingly less relevant. And I am not suggesting disrespect for copyright when I say that copy risk offers us an opportunity to grow the amount of money that's in that pool. When we think of things as actuarial and we realize that our interest is in compensation, collective licensing offers a remarkable opportunity to move ahead in this area. And I want to drive it home before I stop now, and that is that it has become voluntary to pay for music. And it's going to become voluntary to pay for movies if it isn't already for you, and books as well. And if we take that example of music, which is the canary in the coal mine, I'm not saying it's good that it's become voluntary. I'm saying it's a fact that it's become voluntary. I'm not saying legally voluntary. I'm not saying morally voluntary. Bring the lawyers and the priests and the rabbis on. They'll tell you that it's legally and morally a compulsion, but technology has made it a choice that people make. It's a tip jar economy we're living in, and we can't continue it. A civilized society cannot long tolerate purely voluntary payment for arts, knowledge, creativity, culture, what have you. And so we are in a very, very tough circumstance with this. And I will emphasize once again that not only is it voluntary to pay now, but if we hold this meeting next year, it will be more voluntary to pay. And if we have this meeting 10 years from now, as we did back in 1997 in Seville, here we are in 2007. In 2017, I tell you now, it will be more than 20 times more voluntary to pay for music and media. Now, that is the situation that we have in front of us. That is what we have to live with. That is the context in which we operate. And if we take that into account, then we'll take collective licensing a lot more seriously. And if we believe in the delusion that some kind of deus ex machina is coming down in the third act of this opera to save us, to raise us above the flames and everything will be okay, then we are really feeding a delusion that is going to destroy our cultural industries. Deus ex machina is not coming. There isn't one. It's not named Bill Gates. It's not named Steve Jobs. We don't have a technical solution to these problems. We have an economic problem on our hands, and an economic solution is what we need. So, Pat,
Thanks, Jim.
back to you.
Well, I'm not sure that both... I believe what we've accomplished is if there's a bridge there, both sides are standing in the middle going, huh? Steve?
A fact to follow. So I would actually advocate the technology perspective, and that is there are available technologies and to bridge the gap between the consumer and the copyright holder and the rights holder. And I think that as some of these technologies are implemented and put into play in a more daily basis, that you can actually go and have a monetary equation and provide rights holders with the continuation of collection of royalties and distributions, both through monitoring technologies and filtering technologies. So I really, my 2 cents, I'll keep this short, my 2 cents would be, for both sides to leverage the available technologies and to begin to implement them.
All right, so we've heard from our panelists, and it all comes down, I think, to communication and finding ways across this divide. And I think we start with digital rights management. In recent weeks, we've heard from the Viacom chief, Philip Dolman, who says we are staying with DRM. We know that Microsoft announced that it's going to offer more than 1 million tracks DRM free. Walmart, of course, is DRM free. Amazon Store is DRM free. Last week, David Green from NBC said DRM is critically important to protect GE's intellectual property. My question is, from music and movies to the panelists, and they can pick this up any way they like, is what is the future for digital rights management as we know it today for music and movies, where you have considerable restrictions in an age when almost 2 generations have now grown up with the expectation of get it now, play it anywhere. Steve, why don't we start with you?
I mean, I don't think, I'm not a personal believer in DRM. I don't think that DRM has a long-term future. Consumers are, used to using, to accessing content in a different manner, and will continue to find ways to work around the DRM model. DRMs are pretty hackable, so I think that DRM, although some of the major content providers advocate their use, I'm not sure that there's a long-term picture for DRM's marketplace.
I think DRM as TPM, meaning digital rights management as a technical protection measure, will not matter as regards music during the lifetimes of anyone in this room. I think we will actually see their erosion, not their growth. I do not think we can rely upon them. I do think that a kind of DRM, which is a business model which says, have I managed my digital rights well, meaning did I maximize my income, I think that's a very good idea. I think everyone should constantly be looking at how they are managing their digital rights and whether their current management of their digital rights is optimizing their return on their investment and delivering them the revenue that they need. And so I totally support the notion of DRM through business models, through economics, etc. But I think that at least during our lifetimes, that technical protection measures will become less important, not more important.
Copyright societies are business model neutral. They are in the business of licensing uses of works and decisions on how to make those works available or those recordings available to the public are made by others. We sympathize in theory with the idea that it makes sense to try to make it a bit more difficult to just steal property. But I think I would agree with the other panelists that technical protection measures have shown to be kind of paper tiger and probably also a hindrance to consumers. So it has probably created a bad reputation for digital services. So on balance, the DRM technology has not served the creative community very well. We also think that the other kinds of digital technologies can be useful to rights holders to monitor the use of their works, to track the use of their works, and to improve the accuracy of the collections and distribution. So in that sense, we strongly believe that we should use technology to help rights holders maximize the benefits of the use of their works in the digital environment.
I tend to agree that DRM as TPM is a temporary phenomenon. TPMs are basically there because rights holders probably still consider that each song is a discrete property that they own and they want to track it all the way down its use chain. The problem, of course, is users are not looking at music this way, at least not anymore. They're seeing music as one big constellation of stuff out there that is with them all the time on their iPod, their cell phones, and so on. And so that's a disconnect that, unfortunately, TPM is not helping to bridge. You've got also the fact that the social norms at play are important here. If you ask people, especially in universities, which is where a lot of file sharing takes place, when they're asked, is it okay to go to a store and steal a CD, you get an overwhelming majority of no's. It's not okay. Is it okay to get a song without downloading? Much more nuanced answer. Well, I couldn't find it on the legal site, or it won't play on my player, so yeah, I found it on the free site. You see these answers. So TPMs, again, are probably not very useful to answer that kind of issue. If I can refer to universities again and to a solution, if I can call it that I've been describing since 9. I don't ask you to read anything I've written, but on a very boring, rainy Sunday, if you want to, you can check that this is the case. What do you do if you consider that you need to have strict TPMs and prevent use, and you see university students file sharing? You sue them. Fine. Will that increase revenue? I'm not so sure that the last 6 years would bear the case that it does. Another solution, this is the answer to DRM. I think where DRMs actually not as TPMs, but as DRMs with rights management information could be very useful. What if you went to universities and said, you know what, we're going to give you a software client, all of you students here. You'll voluntarily be asked to pay $5 a month, $10, whatever the number is, and you can share with everybody on campus. I would be very interested to see what that does to illegal file sharing and to the industry's revenue. And the thing is that I've been told by the industry, oh, you can't do that because they won't buy CDs anymore. I said, they're doing it for free now, and they're still buying CDs. So why don't you try to get money for that? But anyway, just a thought. This is, I think, something that's going to happen sooner or later, and I think DRMs are, in fact, going to be very useful to make. So soft DRMs that are going to monitor usage hopefully in a privacy-protecting way, and allow everybody to actually make this industry work.
What I'd like to do now, thank you. What I'd like to do now is ask the audience if there are questions that you have for our panelists specifically related to DRM. This would be a good opportunity. We'll take several questions and then we'll move on to another topic. Gentlemen.
It seems to me that colleges and universities have actually tried the experiment that you're referring to from your last comment. In fact, one school, Cornell University, had such bandwidth problems by allowing a community share environment that two things happened. It choked their bandwidth, created systems and admin problems. It frustrated the student body who couldn't provide the service that it was intended for, and it chased them into caves by more and more file sharing illegally rather than legitimately. And I'm not sure that experiment proved to be totally successful in that one school.
Please do.
Absolutely, but in your question you've answered it. It was a bandwidth issue, it was a network issue. Applying Moore's law, hopefully this is a very temporary problem. The problem is the way it was structured to function on one university server does not mean that the concept of the solution didn't work. It means that in that particular case, the infrastructure was simply insufficient. So I don't think it disproves the point. It simply proves that it wasn't implemented properly. And I don't want to go into how technologically what I described, I've run through enough people who actually know, because I don't, how to do this, that it seems it's doable. At, say, within an IP address of a university system or a particular campus.
It's more than doable. I mean, it's got to be done so we can have voice over the IP. I mean, so that we can move television, so that we can move important materials. I mean, in the university context, the internet has become the library. So it's a solution that absolutely must be solved. I think the one thing I'll say in addressing it that I think is critical and I think is worth a great discussion is that I don't believe it should be voluntary. I believe that it's of the essence. I think that we cannot permit our society to make it purely voluntary to pay for art and culture and knowledge. And I think that when everyone is on board, the fees are so small. I mean, you know, the Bill of Rights isn't voluntary, but the argument for it is very, very persuasive. The BBC fee isn't voluntary. If it were, very few people would pay. Those that had to pay would see their rates go up, and it would be like the health insurance system in the United States. I mean, frankly, music and health go hand in hand. They're important hallmarks of a civilized society.
We have to make sure that we don't move into a kind of environment where everybody performs for paying for tips in a cookie jar, like some bands here and some bars in Nashville. That's the concern. We have to also at the same time to make sure that we don't destroy some things that still work fairly well. But I think the case is very clear now. We can't escape the hard questions. If we had been able to plug those holes in the past 10 years, it would be a moot point. But now everybody has the power to download things, has the power to share whatever he or she has, and it's probably unrealistic to believe that we can roll that back. It's a fact of life today. So we have to examine very honestly all the proposals that are put on the table: value recognition, what some people call global license or blanket license, provided it doesn't destroy the other parts of the creative economy. We have to recognize that in this world, collective management is more relevant than before. It's probably the most striking lessons from today's conference compared to the 1997 conference. Michael Kapniger said this morning that he felt that collective management was in danger in 1997, but I believe that it's never been more relevant than today. We have also to give a hard look at schemes that are often criticized, such as the private copying compensation schemes. It makes sense for everybody to be able to enjoy the right to copy some works on devices, on blank sound carriers, without having to ask for permission in a complicated way, without having to click on the license before you can copy a song from one device to another. But at the same time, it makes sense for the people that have invested in the creation of the content, the creators themselves, to be compensated. It's not as good as receiving the full amount of money that you would get from the sale of the CD or from the live performance of the song, but it's better than nothing. And because of the huge amount of copying that is happening every day, it's probably a stream of income that should not be overlooked. We have to make that work very well. We have to be very clear on the distribution schemes for that money, but I believe also that like policy management, private copying, remuneration has a bright future.
It's very interesting that this distinguished panel, who are experts in copyright, come down that DRM is likely not long-lived and TPM going into the future. And so the question that I would have is what do we say to the financial participants? What do we say to the record companies? What do we say to the artists who have spent their hard-earned money? What do we say to the producers during the next period of time when we try to muddle through? How do these guys get through in this economic environment while their materials and their investments seem to be going away? You know, there's an argument for free that I just don't get. You know, you hear some people say free music is going to encourage consumers to buy more music. Well, I don't get it. It's free. Where's the purchase come in? Let's see. Anybody else on DRM? Yes, this woman in the back. Go right ahead. We can hear you.
Oh, hold on. We have to get the microphone to her. It's a TPM. We are in control, and if you exceed the limits, Patrick will, like Mayor Daley, Chicago.
Okay, is that better?
The microphone stops.
I'm Jane Saunders, and I'm sorry to tell you all on the panel that I represent the Motion Picture Association of America, and so I don't think I can engage in the same kind of colorful rhetoric, which was fabulous, by the way, other than to say that I think it's a mistake, or it's much easier. It seems easier sometimes to throw the baby out with the bathwater rather than try to bathe the squirming baby. I want to respond to 2 points that, frankly, I found a little over the top and outrageous when it comes to film. The first, the statement by the gentleman on the end, whose name, I'm sorry, I can't read your card, that consumers are used to, 2 generations of consumers are used to content without DRM. That's certainly not true in the world of film. We have Macrovision on video cassettes, and we certainly have protections on DVDs, and consumers are, generally speaking, not accustomed to getting their content free of DRM in the world of film. And I think it's really important that, at least from my perspective, we draw a bright line between film and music on the point of a compulsory license. I want to pause and reflect for a moment on the irony. I was sitting here listening, thinking we're in a law school and we're talking about the irony of talking about ways to change laws to legitimize illegal behavior is a little funny, but on the practical point of a compulsory license in film, if consumers want valued content, if they want Star Wars, they're not going to get it if what the producer gets in exchange is a compulsory license payment, because we've already addressed some of the points or some of the problems that compulsory licenses raise. One, we have discriminatory treatment of principally, but often not just, U.S. rights holders with respect to national collecting societies or binational, at the hands of national collecting societies, both in regard to the cultural deductions that are made, which we don't benefit in or share a benefit from, and also with respect to discrimination of certain shares that are collected in respect of U.S. films. U.S. producers aren't always cut into those pots, and so collections are made without appropriate remuneration going on the other side. Leaving all that aside, you still have a practical problem in what I call the lowest common denominator approach of a compulsory license. That means that every piece of content is valued the same in a compulsory license regime, be it a 30-minute television series or a 90-minute feature film. And if you remunerate content creators on that basis, you will no longer have any kind of content that anybody, in my judgment, wants to see. So I haven't seen, I don't know, I think that you'd have to beat the breath out of me to accept that a compulsory license solution is ever going to be appropriate for the world of audiovisual works. But I think we're a long way from making the case that a compulsory license is ever going to provide appropriate remuneration, at least in the world of film.
And not one of us used the word compulsory, which you've attacked.
Actually,
I want to be clear. I'm opposed to a compulsory license. And if you thought you heard that in a word I spoke, then you are absolutely mistaken. ASCAP, BMI, CSAC, these are not compulsory licenses. I certainly value voluntary blanket licensing, and I think there's great wisdom in it. And I think rights holders should make that decision on their own. So I doubt you'd hear anyone on this panel say, anybody raise your hand if you're for compulsory licenses. Not a person. So we'll throw that out immediately because no one here supports compulsion in support of a blanket license. I do want to be clear that, it was your industry that brought up a parade of people who put their left hand in the Bible and their right hand in the air and swore that if Sony Universal went the wrong way, your industry would be destroyed. And in fact, since then, we've lived with video cassette recorders and an industry of movies and content and sports and all kinds of things moving. The answer to that, and the reason that the industry wasn't destroyed, is it engaged in a great deal of licensing across networks with lots and lots of services, which I think is the whole point of this panel, is Pat put it up. I don't think anybody here is going to support the idea that things should be free or that there should be piracy. I certainly don't. But I'll tell you, I think we're all a lot better off when we attack the motive and not the mechanism. Because during our lifetimes, we're probably not going to be very fruitful destroying the mechanism, but attacking the motive we can do very well. And certainly there's no one on this panel who would rise to your straw man of every piece of content being valued the same. And ASCAP, BMI, and CSAC don't do the same thing either. When someone stood up at an ASCAP meeting in the early days of ASCAP and said, you're communists, Oscar Hammerstein said, we're no such thing, we're no different than the membership of U.S. Steel. Because it's not one person, one vote in any of these groups. And Eric doesn't stand for that, no one up here does. So what you've attacked, I don't know. It's some kind of straw man that you were sent here with in your head. But not a person here supports compulsory licensing. Not a person here supports every piece of content being valued the same. And so I'm not sure exactly how it fits into any of the remarks that anyone here has made.
Well, let's move on and take one final question
Yeah.
on DRM right here.
Well,
in
I
front.
can't.
This gentleman.
I think we'll have to discuss this a little bit after the session.
Indeed,
perhaps,
we
That'd be
should.
great.
But it's a little juvenile to suggest that replication of digital content is the same as the Sony Betamax situation.
Because it involves the same
that's
thing.
a canard.
I'd like to move on, and I think this will be a great
Yeah.
lunchtime conversation, so I invite you to sit at our table.
Yeah, can I
There's
address
a
this?
gentleman here in the blue jacket. This will be the final question on DRM, and we'll move on.
Yeah, Hugh Hansen, Fordham Law School, victim.
Of short time.
I'm interested. We have to give in because it's going to happen no matter what. ASCAP and BMI is a good example. Before they started out, before there was Buckfeed, Julie LaSalle, everything was free. On the radio, it's free. And restaurants, it was free. Everywhere, it was free. The law changed to make it not free. Here we have a law that says it's not free. You're saying we can't enforce it. They did enforce it. They went out and they enforced it. It changed the culture. People pay for it. Jaywalking. In New York, it's everyone jaywalks. You go to a Copyright Society, went to Venice, California. That signs all over. If you jaywalk, you're going to be arrested. We had 18 New Yorkers waiting for the light to change with no cars or anything else. You can change behavior with it. Now, what you do is you take away you're evil if you enforce it. You're evil if you prosecute. You're evil if you do this. You're greedy. You're horrible. And it's true. A lot of people are greedy and horrible. But consumers are just as greedy and horrible. They have no concern for anyone else. And you're sort of saying that's okay, rather than saying, no, it's not okay. The culture should be you should pay for it or not. And so I really have suspicions if people say it's inevitable. Well, it may be inevitable, or it may not be inevitable. But I actually think you want it to be inevitable. I don't know who the people are on this panel. I haven't read the biography. But usually it's people who have an economic self-interest in it being inevitable, or a philosophical self-interest in it being inevitable, whether it's EFF or something else. I think it's too early to give up on it. That's all I'm saying.
It's not inevitable at all. But we have what I said was that we have to be open to ideas, proposals that help bridge the gap, to use the moderator's first question, bridge the gap between current behaviors, the legal framework and also what we rights holders will want. I think there are interesting proposals on the table. It would be unprofessional, not from us, not to look at them and to see whether they can provide answers to some of the issues and some of the challenges that we are faced with at the moment. Whether we could find other ways for people to pay for the creative content that they enjoy. It's not necessarily a switch. It could be complements. It could be additions to make sure that this huge leakage that is going on at the moment is reduced or stopped. If we insist that we have to do things the old way all the time, I think we are not doing our job properly.
I think it's fine to enforce to send a message that it's not free, but you've got to have a legal system that is as good as the legal one. That's points I was trying to make. To Jane's point, if you read the same papers we're referring to, you'll see I think video is fundamentally different. These motion pictures are fundamentally different. They're not something you listen to on the bus and that you listen to 150 times over. They're not consumed the same way, and I think TPMs actually can be used there totally differently. That's a different topic. And just also, there was a question about voluntary. I'm not advocating a voluntary system. I'm saying it's an experiment. It would have to be. But there are legal questions. And what is the legal basis for, say, a university to tell students, you must pay on behalf of the recording industry? It's not so obvious. I'm hoping that if there's a good legal system out there, even if it's voluntary, that the market will give it value. This is the United States, after all. Market? Anybody? For example, you will not get sued. You will not get spoof files. And guess what? You're doing the right thing. Those are probably compelling arguments as part of a sales pitch. Maybe, maybe not. And the last thing I'll say, and I agree with Eric, I think any such system must have some sort of collective entity to collect the usage data, process it, and make sure the right people get paid. Hopefully the existing collectives for those of them that are here, but clearly it needs to be done that way. It can't be done by individual record companies. It has to be one system. You can't say, well, was this a Sony CD I wanted to listen to? Okay, then I need to use this client. Sorry, but that's not going to work.
Well, that's a very interesting lead-in to the next point.
Yeah, but Pat, just a second. Part of that question was ad hominem, and I want to get at it clearly here. I don't advocate the interests of the EFF when I say this. I work for major rights holders, meaning major sound recording companies, and 3 out of the 4 have been very clear with me, and the 4th isn't my client, so I don't know what they have to say. But they say, I want my sound recording company to make money like my publishing company, because my publishing revenue is up double digits, and my sound recording money is down almost 30% this year. Now, the interests that I'm advocating are those of rights holders who want to maximize their income. And they own publishing companies too, so they see both sides of this equation very, very clearly. And they like how their publishing companies are performing, but they don't, save for the mechanicals, but they don't like what's going on with their sound recording companies, so they want a new regime. They want their money going up. That's my interest.
Eric made a point that we are, the folks on this panel are not about free, but we talked about building bridges, and Eric mentioned alternative payments or alternative ways to compensate creators. Right now we have WE7.com and Rever, and both of them are revenue share models. WE7.com refers to its monetary distribution to its bands and artists as royalty payments, interestingly enough, and Rever shares its advertising revenues with the people who provide the videos. I'd like to ask our panel, and then we'll ask the audience, if this revenue share model that we see emerging on the internet, do you think this has legs, and could this potentially be the beginning of an alternative solution? And maybe we'll start down at the end with Steve.
Absolutely. I mean, I think no one is suggesting that because there's no DRM that people aren't going to be paid. There are a number of ad-supported consumer models that are starting to take shape on the internet in particular that are going to provide rights holders with a rather significant revenue stream. And if you look at the companies, the legitimate companies that are working around that space and working with both some major artists and labels as well as some major brands and advertisers, the revenues could be rather significant. And the models, although they're still developing, may hold true in the long run. There are a number of studies that show that the consumer is more than willing to listen to an advertisement, whether it's pre or post roll, or if a player opens up to see and view an ad, a banner ad, or multiple banner ads, and those are opportunities for revenue.
It's a kind of a Tarzan economics, I think. I mean, I think we've clung to this vine of product for a long time, and I'm not saying we should let go because it pays for people's health insurance in their offices and so forth. And yet I don't think anybody who clings to the vine of the product would disagree that we've got to swing for that vine of service as well. And in the digital economy, music as service, media as service, is a very compelling proposition from which we should glean revenues. And it's one of the ways that we can make a transition from an environment of declining revenues to one where revenues are growing. So I think where rights holders make that decision to embrace those services, I support them. I think that they've got good motives and there are certainly good mechanisms for it.
Well, we should not generalize too much. Models that are relevant for music might not be relevant for audiovisual and might not be relevant for the book publishing industry or the visual arts industry. Mostly those schemes might be applicable to music because of the way music is enjoyed by consumers. It's a mass market. It's even a market that is being commoditized, which is a danger in itself. I'm still very concerned about the cookie jar theory and the Radiohead experiment that we've seen since last week is not very encouraging. It's interesting, of course, and we have to monitor it. But it's clear from the public reaction that the communication has not been very well understood about what Radiohead is making available on their website as compared to what will be on the CD that will be issued. By the way, it's not just a digital release that will replace a CD. There will be a CD, and it's going to be expensive, and it probably will be including other stuff. So people are already talking about double payments. It's sure that if we look seriously at those alternative models, we have to do it in a fairly comprehensive way. If there are a few initiatives like that, it will create even more confusion. But if it's done in a collective way, if all rights holders in a given industry, such as the music industry, for example, agree to speak about that between each other without any preconditions, maybe it would have traction. But if it's done on a kind of confused and chaotic way, it will make matters worse.
Well, don't you see that, would you agree that now at this point in time, with this model being in its infancy, that those bands, those artists, those creators who have not yet reached a point in their career where they are being paid now see this as very attractive, and they seem to be gravitating that way. While it may ultimately be dangerous, I think it's going to be hard to ask those people to forego a payment for their creativity if one's available.
But they shouldn't be asked to forego a payment. Our point is to try to maximize the revenue for artists, for creators, for everyone that is involved in the value chain. That includes record companies and publishers. We are even having a dialogue, CZAC, with Creative Commons to try to bridge that gap also between the so-called commercial and non-commercial worlds, to make sure that people that want to use the flexibility of a non-commercial license because they want to be known, have the chance to move into the commercial world after a while. So we're trying to have a rainbow of possibilities and try to avoid the black and white approach. We can't live in a black and white world anymore because the reality is too complex to allow for that simplistic vision.
Dan?
Well, on Radiohead and others, I think it's perfectly fine for artists, songwriters, and others who want to test new ways of making money on the internet. There's no one forcing anybody to go through the traditional models. Perhaps something good. I think we're getting some good lessons out of that. It's always been okay to give your stuff even if it's copyrighted. But one thing that's very interesting, of course, it's not that these people don't want copyright. If you say, well, you know what, I'm going to take your song, put my name on it, they're going to say, wait a minute. So, and they want copyright, but it's okay to not charge for reproduction or distribution if you want to try it. I think more fundamentally, however, what's going on with the industry is changing the financial flows as you change the distribution channels and the distributors. For example, recording companies probably go to bed thinking iTunes and saying, well, this is a new player, but it's obviously in digital. It's a dominant player. So how do you deal with that with them? What impact does it have on the contracts that I signed before these guys were around, these distributors? That's a fundamental question. Can I still apply the distribution model that I had when we were selling CDs? Not so sure. And if you were to apply the model that I was describing earlier only to universities and colleges in North America, you'd be generating, to do the math quickly, about $3 billion a year. Now, $3 billion is not a lot of money, but it's still not, chicken feed. I did say billion to be. And so if you're going to have $3 billion of new money going around, well, that will have, I suspect, some people trying to get a little, bigger piece of it than they were before, and so on and so forth. So these are things that still need to happen. And I think these financial flows have got to stabilize. They're just not stable as things stand.
We have observations, comments, or questions on the revenue share model from the audience. Gentleman right here in the white tee.
Well, while the mic gets there, I think collectives have a role to play if you're a songwriter also or a composer.
I'm curious who's working with the Consumer Electronics Association really hard on getting some sort of standard formatting for all this, because from my perspective, and I work for a record label, and we're in classical music, so we run less of a risk of any sort of undermarket or black market for Beethoven and Bach. Anyway, so we've always been very open to the open format, and right now I've switched from device to device, and every single time the DRM is ultimately punishment for me. So I kind of compare it to if you walked into Borders or something like that and you bought a CD, but you had to have a specific CD player to play that CD, so that if you wanted to switch your CD players, then you're going to have to go and rebuy another CD that would fit in your new device. So to me, the first step is basically making this format standard, and then from there it might be a lot easier to monetize. But right now, DRM is really, from a consumer standpoint, it's punishment for paying for music.
Okay.
Well, that's why interoperability of DRMs, if we can use that ugly word, is important. If we have technical protection measures, they have to be interoperable in order to not punish the consumer. But there is an industry that works with that system of incompatible formats. Is the video game industry. You can't use the software for a PlayStation on an Xbox, and well, it works. So there are no general solutions to the problems. It depends, but we have to be very flexible and very open, and be willing to listen to what the market is telling us. And the market is telling us that in the case of music, this is a problem. It's not a problem in the case of video games. It's a problem for music. So we have to listen to it.
Thank you. We have another question, gentleman over here.
I think I heard the revenue share. Is the revenue sharing that you're talking about primarily from advertiser dollars or from the situation like you were talking about where you're going to charge people? Because let's face it, we've been using advertisers' dollars on radio and TV forever, and that seems like it'd be one of the logical extensions of what we're trying to talk about here.
Absolutely. I think that is the growing model. I mean, advertisers cannot reach that audience through traditional media. So they're taking those dollars and looking for ways. They want to spend the money. They want to advertise, and they want to reach that demographic. They cannot reach that demographic through TV, through radio, and they're looking for new means. And quite frankly, the internet is that new mean. And attaching it to music is a way to really get a focused demographic.
Even more so if you were to do it in university context and say, maybe you get the option of not paying, and then you get it for free, but you get the CDs out. They're targeted to that demographic. So all these things are possible.
I'd like to move on and talk a little bit about the mobile world.
There's a question.
I was going to ignore that, but you...
Sorry. Thought I was being...
Yeah, ignore me. I'm David Baskin from CMRRA and CSI, and I'll be speaking tomorrow, so I won't speak for too long now. But it seems to me that you're absolutely right in that collection societies are business model neutral. We want to see, as my pal Chairman Mao used to say, 1,000 flowers blossom and 1,000 schools of thought contend. But there seems to be a condition, a precondition to the successful existence of any commercial activity with respect to intellectual property, music or otherwise, and that is that you're rowing a boat. You'd rather there not be a hole in the bottom, or the rowing will be to no end. It seems to me the uninvited guest at the party here is the industry that makes uncompensated use possible, which has so far managed to evade liability in virtually every country, and that is the telecommunications industry, which has yet to be held responsible for providing the means of infringement or controlled or dealt with in any effective way. The analogy I always use is that the telecom companies are sitting outside of a burning lumber yard selling rags and gasoline. And, when someone draws the attention to the fire, they say, fire? We just sell the rags and gasoline. They are the pushers. And everybody who's looked at drug control knows you can't really stamp out drug abuse by busting individual junkies. You got to deal with the pushers. And the pushers in this case are the people who sell and benefit from the sale of access to the media that allow for uncompensated use. We can sit here all day and talk about the comparative merits of subscription or download pricing or advertising back. And they're all extremely interesting propositions. They all present their challenges. Some of them will succeed and some of them won't. But to the extent to which ISPs, telephone companies, cable companies, satellite companies are busy raking in billions of dollars for allowing people to use technology that makes stealing infinitely easier than paying, and as Jim says, has created the environment in which payment for intellectual property has become a choice, we are failing to observe and deal with the principal problem of our time. If we can't plug the leaks, then we're all just having a very interesting and highly academic discussion.
But this is clearly one of those supplementary schemes that I was alluding to. David is absolutely right. It's a big problem, and it can be a big complement to the revenues that all rights holders are getting at the moment. And we should not let the telecom companies off the hook. They have a very extremely important responsibility there, and those are the models that should be studied very hard to monetize things out of their subscriptions.
Well, I think that's very timely. I'd like to move on to the mobile world. Here in the United States, entertainment access on a mobile device is still relatively young. You have the question is, will enough people on the go choose to watch the small screen over the big screen? That seems to be a major question. And will the attraction be information as opposed to entertainment? And so perhaps I'd like to ask our panel what your thoughts are with regard to entertainment and or news, sports, those kinds of things over a mobile device. What's going to attract the customer and make money for the content owner and ultimately for the telcos as well? Why don't we start right here, Dan?
First of all, I'm always a bit amazed to see the amount of money generated by the ringtone industry, especially in Europe. It's very interesting to compare those quote-unquote social norms because these are the same people who are doing the file sharing, with music. And as soon as it becomes an identity issue because your ringtone says something about you, then you're willing to pay. There's something funny there. But I think for music, what's happening is music is everywhere. And the more everywhere, the better. Soon you'll have music when you turn your shower on. It's just music everywhere, and that's why I said the revenue model needs to reflect that in some way, in the way that it's consumed. The video, it's very different. There's probably even a moral rights issue in trying to watch a motion picture on a cell phone, but I don't know if that's true. Apparently there is a market for some movies and some things and perhaps some shorter videos and certainly the YouTube type content perhaps and all that. But I think it's way too early to tell how big that will be, whether it will actually be used simply to support advertising that is sent over these mobile devices. But again, I would separate full-length motion pictures on the one hand, which I think are one type of content, from maybe short clips that are advertising supported, to music. I think these are different things with different revenue models that attach to them, at least today.
I think it's quite likely that it will be different country by country. In those countries where people have to do long commutes in public transportation, Japan, Korea come to mind, for example. It's clear that video over mobile devices is already quite popular. It's probably short clips, news stories, and sports highlights. But in some areas of the world, it will become relevant. I think what we have to wait for at the moment is some solid data from the iPhone, for example, which the business model is based on content. It's the appeal of the iPhone. So when we'll have hard facts, hard figures about how many songs have been downloaded through the iPhone, how many video contents have been downloaded through the iPhone, I think we'll have a better idea of the public's reaction. All the studies that we've seen so far indicate a certain amount of skepticism. People are more interested in HDTV at home than mobile content. It might just be because they're not adapted. They're not adapted to the small screen and the ubiquity that it provides. But it will probably take some time for people to enjoy Star Wars on the cell phone.
I would add that viewing entertainment on a mobile device, unless there is interoperability, as one of my colleagues said, when you can get home and beam your phone to your television and continue to enjoy what you were enjoying on the train on your way home, until that happens, you're going to have a difficult sell for true entertainment as opposed to news, weather, sports, emergency notifications, those kinds of things.
But whatever happens with that, those are closed networks. Network operators have total control over what's going on in telecommunication mobile networks. So those guys should be liable for copyright payments. There's no excuse. This is not the internet, not at all.
Yeah, Eric, I'll disagree with the last statement just slightly because, well, in principle you're right. The problem is that if I have a device and I load encryption on it, and the content's in my house and I encrypt it there, it's just transported between, so it's very hard for them to control. But I'll agree with you; it shouldn't let them off the hook for compensation. So I'm certainly not opposed to that. I think, Pat, in direct answer to the question, I think video is already proving disappointing. At least my clients who make handsets and so forth say video has not proved to be the killer app for the mobile world. I think it's primarily because when you are mobile, you need your eyes for safety, and so you use your ears for recreation, whether you're an American driving a car or a European walking down the street. I think the experience is roughly the same. I do think
European streets are very dangerous, I agree.
Well, very, very dangerous, and of course,
And there's no jaywalking, and we heard that.
Yeah. I think what we've got to say here in Music City is that audio is the killer app for the mobile world. And here's that's the good news. The bad news is that if you think you're in a world of change, it hadn't even begun. In other words, the notion of music for cubicles, getting it over a copper wire or to your desktop computer at work or at home or at school, that's going to give way to a world where we are awash in digitization. And we get all the digits we want wherever we are and whenever we want them. Quite simply, our music, downloaded or on discs, become traveler's checks in a world of ATMs and credit cards. And so the product-to-service transition, I think, is accelerated dramatically at that point. It's good for us if we can adapt to music the service. But if we continue to cling to music the product, we will find that the circumstances become more and more tough as your motive to carry music around falls. I mean, let's be clear. Our current business model, if I understand it right, is that devices that can currently hold 40,000 songs will double in power and halve in price every 12 to 18 months, which means 80,000 songs, 160,000 songs. We think you should pay $1 for each of those songs. So a child would be sent to school with a device that's worth more than their annual or perhaps entire lives' education. And that this is our business model. And that is problematic in a world where once you can get all the digits you are, wherever you are, whenever you want them, you cease to desire to carry them around at all. And so that's a fundamental transition that we have to meet forcefully. And by the way, it's not all doom and gloom. You know, if you do the spreadsheet numbers, many hands make light work of the fees we need to grow our businesses. By that I mean we can double, triple, quadruple our income in a world like this. But if we continue to cling to this notion of control and product, I don't think we'll get there.
Steve, do you have a comment about mobile video entertainment?
Well, I would echo what Jim said, that music is the killer app for mobile. I'm not sure about video. I'm not sure if the devices are ready for video yet. But I think the signs regarding music on mobile, the clearest sign is that not too distant future BlackBerries will have mobile music apps on them, and so they're obviously moving away from the business information needs that they typically provide to their users to an entertainment need, and the first one they're going to provide is music.
Right. I'll close up that segment by just making an observation that the telcos are putting pressure on the producers and the content owners for television program, full-length movies, those kinds of things, to deliver those that content with the rights having already been cleared, which is interesting if indeed we're not going to have the attractiveness that draw the audience, that draw the advertisers, that make the money. So for those whose function and tasks it is to be sure that you monetize those full-length movies and television programming, I think we need to monitor this situation very carefully. I'd like to move on to, I think, a compelling topic, most fitting while we're here in Vanderbilt Law School, and that is recently ASCAP and those who support copyrights was disappointed by a rate court decision that determined that essentially there was no performing rights implicated in a download. The distinguished and honorable Register of Copyrights is here as well, Mary Beth Peters, who also espoused that position. My question to the panelists, and then open to the floor, is in today's environment, when listening to a copyrighted musical work is or can be simultaneous to the download, with perhaps a limited exception of a nanosecond or two for the buffering, do you think that a download does or could implicate both rights? And let's start in the middle with Eric, and we'll let everybody pick up where they want.
Well, I'm not a copyright lawyer, but it seems to be generally accepted reality around the world that streaming and downloading involve both rights, and because in the technical processes you have temporary reproductions when streaming is taking place, and I'm not even sure that those reproductions in the case of streaming are that temporary. And in the case of downloading, you have ways to listen to the download taking place. So I think the decision in the United States is a bit unfortunate. This is the United States, so it will be looked as a precedent in other countries that have not established their position, and I hope that this will be changed at some point. The disappointment also in those cases has been that other rights holders have not been that supportive of ASCAP's position, and I'm not talking about other PROs, but other rights holders. I think if we are to build a better future together, I think we should be more supportive of each other.
Here. Couldn't agree more.
I don't think it's a zero-sum game. I agree with you. I think our goal here is to grow the pie and not fight over a limited one or a shrinking one. for very technical reasons, I thought the decision was unfortunate because as a technologist, I know that Ethernet is a broadcast medium. In other words, I know very well that every computer on a network receives every digit sent to any computer on the network, and that for in a very hyper-technical way, every transmission, even for download, is in a way a broadcast. But let's cut to the quick and get past the technicalities here. The difference between streams and downloads are very unfortunate for public policy because the differences are intent and result, neither of which can be monitored externally. What I mean by that is that a stream is intended to be used in the time and place in which it is offered. Unless, of course, it was buffered and saved, in which case it became a download. But we don't know it from outside the network because we don't know if they buffered it and kept it. And a download is intended, of course, to be used at any time or any place, and yet some people download them as soon as they, or delete them as soon as they've downloaded them. And so we know that some downloads behave like streams and other streams behave like downloads. And frankly, to me, they're all DPDs, the delivery of phono records by digital means. And so I think the distinctions between streams and downloads are disappearing fast and for our purposes need to. And what we need to get through the point is that quite simply, as a practical result, and by the intentions of what we mean when we say copyright, is that everybody's got to get paid so that the incentive to create remains. I think we can become very, very hyper-technical. But there was a point where I went to Cornell School for negotiating, and they made a very, very important bottom line point at Cornell's negotiating school, which is that when you have trouble splitting something up, you need to get past people's proposals and start to look very closely at their interests. And so whatever proposals we bring for getting paid, we have to let go. And remember that our interest is in remuneration, is in getting paid, and preserving an incentive for creating and delivering this wonderful culture and art that we're all here to honor. So that's the point. Make sure everybody gets paid. Let go of the petty divisions between streams, downloads, broadcast, non-broadcast. We've got a lot of people who got to get paid. We got to pay them all, or we're not going anywhere.
Well said. Thanks. Steve?
I think from a technology perspective, there's virtually now no difference between a stream and a download. With the increase of speed on the bandwidth and speed of computers, as soon as you hit a download, it's opening up and playing. So,
Ironically, I published a paper on this in Vanderbilt Journal, International Law in 2002, and I said it could cut both ways, but there's two. I think we're mixing up two things. There's the descriptive matter that I think the Register was right. If you read the statute, the definition of performance and so on, come out in one way saying, well, if it's a pure download, no, it's not a performance, and that's a perfectly defensible way of interpreting the statute.
Can you define pure download for us?
Well, that's it. That's exactly where I was going to go to the point made by the last two speakers, which is that pure download category, as distinct from a stream, is becoming harder to make as technology progresses. So as a normative matter, not as a descriptive matter, should it be different? That, I think, is a different question. I think we have to separate them and say, well, perhaps in the future, yes, they should not be. But let's not confuse the issue of what the statute says now and the perfectly defensible view that it's not a performance if you're strictly downloading, though the other view, as I wrote in that paper, is also defensible. And the normative view that in the future say, well, perhaps we should, in fact, have a single right. The WCT, as Dr. Kitcher mentioned this morning, took an approach, just making available, which may or may not be a fabulous idea. It was a fabulous idea to get the treaty done. Whether it's a fabulous idea in terms of how it's implemented, as Help said, we can talk about that.
Questions from the audience? Let's start on this side. Anybody? Comments? Gentleman right here, green jacket. How many microphones, please?
Peter Janner from the International Music Managers Forum. I think it's really important that we should remember that copyright is the grant of a monopoly right by the public, that we are very lucky to have it. and that when the consumer, who is also the elector, feels that he's getting a bad deal, he's going to undermine our monopoly rights. First point. It is not, therefore, a divine right. And the key then, to me, it seems to me, that we have to maintain legitimacy. We have to maintain a feeling in the consumer, in the public, that we're making a reasonable deal. It seems to me that quite clearly the public has demonstrated that they do not consider the same price for a piece of music which they deliver to their own computers at their cost as a broadband, and they burn and so on and all the rest, as the same value as going into a record store. And that, I think, is quite clear from the behavior of consumers worldwide. So that we have to accept that the consumer price that would be acceptable for a fully per unit item is likely to be so low that we can't possibly split it. It's just a complete waste of resources to try and split every possible use. So it seems to me that we have no choice but to come to some much more global approach, as Jim is suggesting. And I think then that in turn means that implicitly we have to accept that the de jure administration of exclusive rights is becoming online very, very difficult, and that we have to accept a de facto remuneration right. And I think that's necessary for all of us. And I think that really poses huge problems from the way we think and also for the way that contracts are written. And that in turn, I think, from the recording industry's point of view, means, as Professor Gervais pointed out, there's some real problems in the record industry's contracts.
Thank you for his comments. Any other questions, observations? Mr. Gertz.
Ron Gertz, I'm the CEO of Music Reports, Inc. My company, by the way, I have to thank those of you in the room who are part of collectives or collectives of collectives. It's because for giving me such a nice business. Why? Because my company represents media companies that have to navigate the rights landscape to get licensed by all of you. The fragmentation of rights that you have all foisted upon the industry for legitimate reasons causes legitimate people who want to pay royalties intense problems. So we get hired by major media companies to navigate that rights landscape, to negotiate with the collectives wherever we can, or to negotiate directly with copyright owners where we can't. Now, how do we deal with the problem of the fragmentation of rights? When we deal with copyright owners, we don't care if it's a performance right. We don't care if it's a reproduction right. We can't deal with the definitions. We don't care if it's a lyric reprint right. We don't care if it's a display right. We don't care. We get what we call a functionality license. We say to the copyright owners, just give us license to do these 5 things we want to do, and tell us how much it costs. Don't fragment it. Tell us how much it costs. Tell us how much to pay and where to send the check. So
you can make the check out to CSAC and just send it. We'll take care of this.
And if you could grant all the rights, we would do that. So part of the problem, folks, unfortunately, is, and I say this with no disrespect to my good friend David Baskin, or to Marvin Berenson, or to Fred, the rights involve collection methodologies that with separate collection organizations. And when those rights merge in terms of functionalities, somebody's got to go. So the issue is functionality and value for the user community. Now, I'm speaking on behalf, not on behalf of, I'm speaking with the hat on, of people who want to pay the royalties. They want to pay. And if they can't pay the intermediaries, they'll find a way to pay the owners. Thank you.
Last question on this topic in the back. Yes. Patrick, how much time do you have left?
10 minutes, I guess.
10 minutes or so?
Hi, Michael Sukin. I was here this morning. With all due respect, technology and modalities are not copyright. Copyright is right. And that's just my answer to some of the things people have been saying. But I have a question. It's probably directed at Eric, but perhaps there's someone else in the room that can answer it. With regard to that Second Circuit decision, elimination, in my view, of one of the rights. Do you think that there is an action, a la EMRO, the WTO, that some country can bring against that sort of a decision? Is it similar to blocking out a minimum performance royalty in our legislation in the United States? I don't mean to put you on the spot.
I'm not legally qualified to answer that. It's way too. But probably
That's a very interesting question.
Maybe.
The answer is maybe. Great.
But it's a long answer. So, well, look at the treaties and see. You will not find a definition of what a performance is in the way that you've just described. So you've got now the WTO panels have accepted to look at the history of the Berne Convention. So then you have to look at the history of the convention and the way it was interpreted at diplomatic conferences and so on. And it would not be an easy case to prove that based on that, in any download, there is also performance. It will be an uphill battle, but I mean, the world expert on this is Dr. Fitzshore, so maybe we should give him for 10 seconds.
Good, Doctor. Right here.
Coming behind you.
Yeah, watch out.
It's a race.
You're getting two. You're getting two.
There you go. Getting stereo.
I may use it in a stereo way, perhaps. I like to say that I like Mary Beth Peters' idea. It may not work so easily in the United States, or it may not work, but that would be a solution. What she has proposed once, and wasn't accepted, musical right organization. It does exist in Europe. GEMA in Germany is a musical right organization which manages both performing rights and mechanical rights. Artistus Hungary is a musical right organization in this sense that it manages both rights. Of course, it's not the only possible solution to set up a new organization, but some kind of coalition between, let's say, United States, ASCAP, BMI, CESA, and Halifax Agency to solve this problem would be a common interest. It may take the form of a new common organization or to settle it something. In that case, the legal characterization of these two rights, in the case of streaming and downloading, performing rights and right of distribution, would be just a matter of calculation within the same system.
I usually don't disagree with Mihaly, but I think there is another issue there, not just how you approach the users, but the split between the various rights holders. And the splits between so-called mechanicals and performing rights are different. So if the decision stands and there is no performance in a download, then there are some rights holders that will be unhappy.
I'd also like to add to that I don't view part of the problem the fact that there are three performing rights organizations and a dominant mechanical rights organization. I don't see that as part of the problem. The issue really comes down to the advance in technology as to whether there is, in fact, a reproduction and a performance at the same time. The fact that you might have to go to 4 different places or perhaps 3 performing rights organizations and a compulsory license, I don't think is a daunting hurdle for those who seek to obtain licenses.
I think we're going to need some kind of a super collective that wraps it up. I mean, I think Mary Beth is right in the sense that when you look at it from the outside, we're like that liquor bottle that's up on the 10th shelf behind the counter and no one buys it and it just gathers dust. And it's not clear how much it costs or how good it would be or what it would be worth. And so I think we'll need some kind of a super collective, and then I think we should gather the paramedics and locate ourselves near a hospital and settle it out amongst ourselves.
There's a solution also, which does not mean merger, which is the Canadian solution and other. I mean, the copyright board just looking at you're thinking, but they basically said it, correct me if I'm wrong, but not to merge collectives, but to say in certain cases we're going to look at the license, a bit the way Ron mentioned, as a single economic operation. From the user perspective, it doesn't matter if it's a download or they want to pay for what it's worth, period. And so let them pay for that, get the money in one place, and then split it. But I also have something to propose, which is if you have this thing in the United States, you could call it, with BMI, ASCAP, say Zachary Fox, BESH, call it BASH, and have it...
To my point, locate near a hospital and invite the paramedics.
Well, thanks. Let's move on. In the United States, the radio industry, which will stand up and tell you that they are directly responsible for breaking every artist from 1930s forward and every nickel that's been spent for every record, disc, tape, what have you, has been for the last half dozen years or so a relatively flat business, flat as far as revenues, up or down a percentage point each year. There is emerging in the United States this technological revolution in radio, which I think is the only one that happened since FM, which is high-definition radio. High-definition radio is going to allow essentially 12,000 commercial radio stations to turn into 36,000 streams of music. And so I have several questions for our panelists, and then we'll turn it over to the audience as well. First, will HD radio be a savior to the radio industry? You know, in today's environment, when we're talking about you're going to have the, what was the number you used, 180,000, Jim, of your favorite songs on your telephone and get it whenever you want. And when you're also going to have your phone can access the internet so you can get your local traffic, weather, emergency calls, and all of that, what is the viability of radio here in the United States, and does HD radio improve its outlook for the future? And we can start anyway on the panel.
All I will say is very brief. I think, first of all, we're testing in terms of what people carry with them, the limit of what is the possible universe that somebody wants to listen to. How many songs is it that a person realistically might want to listen to over a certain period of time? Is it 10,000, 40,000? I don't know, but we're testing that. I don't think 300,000 is the right number. It's probably not that, but I don't know what the right number is. But what's happening with radio, especially this high-quality radio and the subscription radio models, is part of this music everywhere phenomenon. That you listen to the music you want wherever you want, not the music that is being pushed to you. So that's the change that's happening. And so what the radio industry is doing seems to be compatible with that trend. That's so I was.
Well, as somebody that spent 10 years in the radio industry, this is an issue that is close to my heart. It remains to be seen how radio can reinvent itself in this sea of music that is following us wherever we are or go. If the radio stations are able to offer compelling exclusivities, premium content, pushing things to people that own iPods that have 45,000 songs and drawing their attention to new exciting talents and new releases, I think they have a very, very good future, because there is only so much that we can discover on our own. We need people to draw our attention to stuff. If the business model of digital radio is like those highly themed musical channels that you find in some satellite systems or some cable systems, our music choice, I think the future is much bleaker, because that is the wrong compromise. It's not interactive, and even if you have 250 channels, it's still very limited.
Well, I mean, there's, I think, two major answers. One, if you look very carefully at your proposition, Pat, which is HD radio, it's stillborn. This is a mass media that the masses have completely ignored. There are less than 1 million radios in the United States, and it's because the radio industry didn't intend for it to succeed. The radio industry looked at DAB in Europe and said, hey, there's a lot of new entrants over there. And look at what happened to us with cable. Every one of us lost market share. So let's build something that will have no new entrants. And so they came up with iBach HD, which is in-band on-channel, which frankly just means you have to own a radio station already in order to add digital to it. And to pour oil on this terrible fire, it's only 96K, so it's not even high quality. Once you split the 96K 2 ways, 3 ways, 4 ways, add data, it's positively crippled. So it does not work very well. But to the broader proposition, which we should be focused on, and I think that's where Eric took it properly, is the digital radio. And I hesitate to use that word radio because it's a very insidious word that makes it sound like it has every right to compete side by side with what we called radio. But in fact, it has unlimited geographic reach. It offers the opportunities for interactivity. What it offers are not advertisements, but direct consumer buys. You know, there are any of a number of ways that this is a new medium, not analogous to the old medium of radio. But make no mistake about it, it's coming and in lots of flavors. 700 megahertz spectrum auction will lead to dramatic growth in this area in the U.S. WiMAX 2 will bring us closer to people using this in cars. But I'll just close out by telling you the real problem here. And it's just contained in 2 words, and those are audio TiVo. You know, we live in a world where people, at least in the United States, and I think increasingly worldwide, feel entitled to own a TiVo. They feel entitled to own a video TiVo, and we won't pry them from their cold, dead hands. And as a result, the notion of an audio TiVo seems relatively simple. Of course, if I can have a video TiVo, why can't I have an audio TiVo? But here in Music City, an audio TiVo is far more savage upon the business model than is a video TiVo. And I say that because, as I think it was Eric said, you know, we use music very differently. We play songs over and over and over again, and maybe a television show we watch once, twice, you know, a movie, etc. And so when we grow into a place where audio TiVos are acceptable and by right, that is when streams become downloads. That is when option value transfers from product to service. And everything we've done to price music misses this entirely. And if you want to make music more than feel free, but actually be free, let those audio TiVos carve their way into our society. And every car is going to ship one. And by the way, a few do now. The Mitsubishi Montero advertises that it has a 40-gigabyte hard disk, and you never need to insert a CD twice. It won't be a too far a step to say, and we've got HD radio, and you won't have to listen to a song twice. You can simply call it up again. That's where our business model has trouble.
Jim, we only have 3 minutes left. I want to open it up for questions, and maybe we take 2 questions before we take the cutoff sign. So anyone on the phone? Yes, please.
Hi, Michael Milius from AMPRO, Performing Rights Society on the Caribbean island of Anguilla. Question to Jim Griffin. Jim, you had mentioned collective licensing. Could you tell us more about that as a solution?
Oh, well, sure. I mean, most of us here at the conference know what it is, so I won't redefine it, but I'll just say simply, you know, I like the idea that when we lose control of something, that we substitute actuarial economics, that we come up with the pool of money and the fair way to split it up. And I'll just say as simply as I can that our situation is not dissimilar from that of ship owners in the late 1600s who were asked to carry molasses to the New World. When someone comes and asks you for your music, it's sort of like coming to ask someone for their ship. What happens if I lose the ship? Can you pay me enough money to replace the ship? A set of bankers were sitting at the other table in a coffee shop in London and overheard the conversation and said, yeah, there's a solution. Let's build a pool of money and a fair way to split it up. We'll write our name under the name of the captain of the ship on the wall. The coffee shop was named Lloyd's, and thus was born the business of actuarial economics. We need to find our way to that same spot, and we have. Even as recently as 1998 with the DMCA, we created Sound Exchange in the United States to help sound recording owners recover money that was being lost on networks with webcasting, with billionaires like Mark Cuban out there. And unfortunately, it's a compulsory. I think those involved, if they had it to do over again, would say, let's do it voluntarily before it's imposed on us. But it certainly doesn't pay every copyright owner the same, or the same for every song, or value them the same. And it's a far better solution than the rest of the world is experiencing, which isn't monetizing webcasting at all. So that's what I'm saying, is let's move forward, build pools of money privately, as did Lloyd's, and let's compensate ourselves for the risk that our products and services face on networks, which will only grow and will not reduce during our lifetimes.
Well, I think we're out of time. I want to thank the audience for your participation, and I'd like the audience...
You guys were great.
I would like the audience to thank the panelists for their participation.
It's a pleasure.